We'll hear the argument number 1, 2, 3, 4, 5, 6 today. Francine Noyce versus the Director of the Missouri Department of Health. Ms. Fish.
Thank you, Mrs. Chief Justice, and may it please the Court. Francine Noyce is a 32-year-old Missouri woman who is in a persistent vegetative state, which means she is permanently unconscious. All thought, all memory, all ability to interact with the world around her in any way is gone. She'll never recover. Francine has been in this condition for over 6 years as a result of a car accident. 3 weeks after the accident, her parents consented to the surgical insertion of a gastrostomy tube necessary to free Francine. The family was not told that their consent was irreversible, and no one suggested that the insertion would render Francine in an indefinitely unconscious state.
Here with us today is Dr. Wu, who has some information relevant to the matter at hand. Dr. Wu.
Thank you. By Missouri state law, Ms. Noyce doesn't have the right to a medically assisted death. Almost everywhere, it is a crime to assist someone in killing themselves. So it is argued that medically assisted suicide is no different and shouldn't be legal. Only 5 states give patients the option by state law to medically assisted suicide. These states are Oregon, Washington, Montana, Vermont, and California. The Californian law is effective on June 9th. In Montana, it is an option only through a court's decision. There are 9 other states that currently have a pending medically assisted suicide legislation.
Was the family's consent required at the time of the insertion of the tube?
By state law, the family's consent was required for the surgery to insert the tube. It would have been a battery for the doctor to perform a surgery without consent. And the only exception to that in Missouri is the event of an emergency. If a person is in imminent danger of dying and there's no one around to provide the necessary consent.
What if the parents had denied permission for the operation?
If they had refused, the state would have accepted that refusal, and that Francine would have died from severe brain damage. So the issue before the court is what constitutes as sufficient evidence that an incompetent person would have wished for a medically assisted death.
In this specific case, we have the factors that Miss Noyce is in a vegetative state, that she's permanently unconscious, and that she said to a friend a year before this accident, "I wouldn't want to live life as a vegetable." So the question then is, do incompetent people, such as those in a coma, have the right to die?
I do personally think that they should be able to make that decision.
No, because sometimes if you're in that state for a certain amount of time, like you can wake up. Like there are many cases that did happen before, so you could wake up.
That's a hard question, because sometimes medical miracles do happen that doctors cannot explain.
Well, if they never got their approval, like if doctors never got like the right for them to do that, then they shouldn't. But
It would be difficult for a person to be in a state close to the vegetative state and still be competent enough to make their own decision like that. But I believe the 14th Amendment protects that person's rights to be free from a state intrusion.
But is there enough evidence to prove that Miss Noyce would have wanted her family to reject the surgery?
This limited amount of evidence is applied to a state standard so high that the state will always win. It simply isn't enough evidence. The state decides based on the situation, but for this case, Francine's statement doesn't prove she wouldn't have wanted the operation.
So the question becomes, who decides? Francine Noyce said, "I hope my family would know I wouldn't want to live as a vegetable." And that's important because families get to make these kinds of decisions. So, can her family make that decision?
I don't think they should know because it's the person's life, so they get to decide whether they die.
I mean, if somebody is mentally incapacitated, I'm thinking that they're not able to make that decision, so it would have to go to the next of kin or the family that would be responsible.
Honestly, I disagree with family members making that decision because if there's no evidence that they wanted to die, it's not true, or it's probably not true that they did want to die, and then the members might end up making the wrong decision.
I do not believe so. They're their independent person. They're their own person. But if they're younger, they might not know well enough. And the doctor sees that, then the family can make a decision.
I feel like they can because, it's their family members. They lived with them. They went through they were with them step by step to all the procedures and all that stuff. And they were just there with them, so they probably know what's best.